Hi, good morning and good afternoon, everybody. Thank you for joining today's Government Contracts Academy CLE webinar, the State of Government Contracting in 2021, a review of key developments for last year and an outlook on 2022. I'm Gail Monahan. I'm a partner in the Dallas office. I'm joined today by Caroline Colpoys, a managing associate in our Dallas office, as well as Michaela Colvin, an associate in our Denver office. This is the first session of 2022 and the second year of our Denton's Academy program. We really enjoyed presenting for you all last year, so we thought we'd do it again this year. We appreciate your participation and your helpful questions and insights that you shared with us last year. You know, we're planning to continue this throughout the year. We're going to talk a little bit about some of the programs that are coming up, but if you have additional ideas for topics or things that you think would be of interest to our audience, we would welcome your feedback. So please let us know. Before we get started today, I have to cover a couple of housekeeping items. For the benefit of the participants, attendee lines have been muted. Should you have any questions throughout the course of the program, please leave them in the chat box at the bottom of the WebEx app, and we'll do our best to get to those today. If we can't, then we'll try to follow up with you after the webinar to get your question answered. Please note that today's webinar is being recorded, and a copy will be circulated to the registrants after the event is over. But it's important to note that Denton's can only give you CLE credit for attending during the live broadcast of the webinar today. So that's kind of an important point to keep in mind for CLE purposes. A couple other important points about CLE credit. In order to obtain your credit today, you need to keep the window open for the entirety of the program. And it must be the only window that is open on the forefront of your screen. WebEx can detect if you minimize the program or you're using other software, and this will prevent you from earning your CLE credit. One other important point about CLE credit, if you have a bar license in New York, New Jersey, or Pennsylvania, please listen for the code word, which we will give about midway through the presentation. When prompted, you will need to enter the code word into the chat section of the screen. If you don't do this, you're not going to be able to get your CLE credit in New York, New Jersey, or Pennsylvania. However, if you're not seeking CLE credit in those three states, then you don't need to worry about the code word. One other final point on CLE, this program is approved for 1 hour of general CLE credit right now in Arizona, California, Illinois, Indiana, Missouri, New York, and New Jersey, and it's pending approval in Colorado, Georgia, Iowa, Pennsylvania, Texas, and Virginia. Before we get started, I also want to highlight here on the next slide some of the other programs that we have scheduled for this year. We're going to cover government contracts IP, ethical considerations in internal investigations, cybersecurity, and then we're going to finish the year with key cost and pricing updates. And as I mentioned before, if you have thoughts on other topics, please let us know. We're always happy to take your feedback on that. Now, with that out of the way, let's get going on today's session. As you can see here from the agenda, we're going to cover a number of topics, a number of things that happened last year, things that are happening this year, things that we expect will happen later this year as well. There's been recent developments even within the past week on, antitrust issues and things like that we're going to try to highlight for you all. But first, so Michaela's going to first talk about COVID-19 related issues that are still, working their way through the legal system and certainly impacting contractors. Caroline is then going to talk about a number of cases and regulatory updates that we think are of interest to you. And then I'm going to talk about a few other things that are seemingly going to happen in 2022. And with that out of the way, I'll turn it over to Michaela.
Hi. As Gail said, I'm Michaela Colvin. I'm an associate with the Denton's Government Contracts Practice Group, and I'm excited to be here virtually today to talk with you a little bit about what happened in the government contract sphere in 2021. With pretty unprecedented impacts on domestic and global economies, supply chains, work arrangements, housing markets, consumer habits, and pretty much everything else you can imagine. It would be fairly difficult to have a full discussion on the goings on in 2021 without at least touching on COVID-19. As you are all likely pretty aware, in September of 2021, President Biden issued Executive Order 14042. I will refer to this as the executive order for the purposes of our discussions today. The executive order instructed federal agencies to contractually require certain federal contractors to implement COVID-19 safer workplace guidelines, which included a vaccine mandate, which we'll talk about primarily today. At that point in time, we were receiving many questions from clients about the reach of the vaccine mandate, about implementing the flow down requirements to subcontractors. And while contractors like our clients were struggling to establish compliance policies for their own workplaces, and also were trying to determine how to properly flow down the safer workplace guidelines to their subcontractors, there were some states in the background filing lawsuits challenging the executive order. The first of these challenges, lawsuit challenges, came down in September of 2021, pretty soon after the executive order was issued, but several additional states followed suit throughout late 2021 and even into early 2022 in Florida. These lawsuits generally argue that the executive branch didn't follow certain required procedures for implementing changes to the federal contracting requirements, or that the executive branch just didn't have the authority to issue the mandate altogether. While most of these lawsuits resulted in preliminary injunctions in select states that only applied within the borders of individual states, the most notable of these suits is probably Georgia v. Biden, which resulted in a nationwide injunction on the enforcement of specifically the vaccination mandate included in the executive order. Notably, several of the other state-specific injunctions in Louisiana and Florida specifically extended enforcement prohibitions beyond the vaccination mandate in certain circumstances. So in Louisiana and Florida, it's possible that the government is also prohibited from enforcing things like mask mandates under the executive order, social distancing, etc. The National Preliminary Injunction Order was issued by the Georgia Federal District Court in December of last year. The government appealed the injunction, of course, with the 11th Circuit, and also filed a motion to stay the injunction while that appeal was pending. The 11th Circuit denied the stay. So the injunction remains in force today, and at least through oral arguments at the 11th Circuit, which are scheduled for April of this year. It would be good to keep an ear out just for the outcome of those, because they may have a pretty significant impact on how we address the vaccine mandate moving forward. In addition to its motion to stay the injunction, the government moved for clarification of the scope of the Georgia Federal District Court's injunction. The motion for clarification asked two questions. The first was whether the injunction applies only to the enforcement of the vaccination requirement, or if it also extends to the masking and physical distancing and other requirements under the executive order. The second question, probably the more important question for our discussion today, was whether the injunction, quote, prohibits private federal contractors from mutually agreeing with the government to include COVID-19 safety clauses in their federal contracts. The Georgia court denied the government's motion for clarification, but in its denial order, did some clarifying anyway. It confirmed that the injunction only applies to the vaccination requirements. This means that the government can enforce against covered federal contractors the executive order's social distancing, masking, and other safety requirements as far as the Georgia court is concerned. Again, just to remind you, other states may have other restrictions, and we can speak about that separately, but is a little bit outside of the scope of this conversation. The Georgia court, however, declined pretty explicitly to rule on the government's second clarification. It likened the content of the request to an advisory opinion on the propriety of a vaguely described hypothetical situation. The court's avoidance leaves open a question of whether the government can enforce obligations that are established in contract terms that are mutually agreed upon related to the vaccine mandate. Since the Georgia court's order on the motion for clarification was issued, we have had some comments from clients indicating that their government clients are continuing to attempt to include the COVID-19 government contracts clauses as they relate to the vaccine mandate within new and pre-existing contracts. Agreement to include the COVID-19 clauses is generally accompanied by an assurance from the government that it will not enforce the vaccination element of the executive order until the relevant litigation is resolved in favor of that, if it ever is. We bring this to your attention just because opting to voluntarily include the COVID-19 clauses in contracts does present a pretty significant risk to contractors given the judiciary's uncertain position on the legality of enforcement of contract obligations related to the vaccination requirement. A contractor, in other words, who voluntarily accepts the COVID-19 clauses without any sort of written indication in the contract of the promise not to enforce the vaccination requirements is essentially just relying on the goodwill of the government and could eventually become the government's test subject in that vaguely described hypothetical situation that the Georgia court described. It's never great to be a test subject, so keeping this in mind is important. Next slide for me, Gil. Oh, excuse me, no, you're on the correct one. Sorry about that. In many cases, however, contractors are still accepting the COVID-19 clauses with the vaccination requirement or had already accepted them prior to the nationwide injunction. This leads us to the question, given the ongoing litigation, what actions may a contractor take once the clauses are in its contract? There are certainly many approaches that a contractor could take. I'll highlight 3 today, but as you can imagine, there are infinite variations of these approaches. The first I'll call the business as usual approach. In this approach, a contractor could potentially proceed as if the COVID-19 vaccination element, the COVID-19 clause vaccination element was being enforced in the typical way that all government contracting clauses are enforced by applying the vaccine mandate to its own employees and also flowing down the mandate and enforcing it against covered subcontractors. The second approach I will refer to as the mirror the government approach. In this approach, a contractor could mirror its government client's action by flowing down the clauses to its covered subcontractors, but also promising to only enforce the vaccination mandate if and when the relevant litigation resolves in favor of enforcing the mandate. This approach could also include developing internal vaccine mandate implementation policies for the contractor's employees, but also not enforcing those until the litigation resolves in favor of enforcing them. The final approach I'll call the accept and hold approach. In this approach, a contractor could accept the clause in its own contract, but completely hold off on taking any other action with its subcontracts and employees until after the litigation resolves in favor of doing so. Of course, whether or not you want to accept the vaccination mandate in a COVID-19 clause or how you want to approach it once it's in your contract is as much a business decision as it is a legal decision. So it's definitely a case-by-case consideration, but none of the approaches that I mentioned, and really any of the approaches you could imagine, are without risk. For example, if the pending litigation with states, the Georgia v. Biden litigation and all the other cases were to resolve in favor of resuming government enforcement of the vaccination terms, it's hard to say how much time the government will actually give contractors to comply with the mandate. The mirror the government approach that I described previously and the accept and hold approach both potentially risk a last minute scramble to ensure contractor and subcontractor compliance with a potentially short deadline. In this hypothetical, the accept and hold approach is of course even more risky because additional steps have to be taken by the contractor during the potentially short time period to ensure flow down of the COVID-19 clauses to existing subcontractors, application of the vaccination requirements to employees, etc. The flow down of the COVID-19 clauses to existing subcontractors would likely need to be done through contract modifications, which, as we all know, are sometimes costly or even impossible depending on the terms of the subcontract. The contractors adopting the business as usual approach are also not immune from risk. They can face legal challenges from their employees or subcontractors concerning their enforcement of the vaccine mandate when the government is prohibited from doing this. By example, I don't have this case in the slides mentioned specifically, but I could put the site in the chat when I'm done here. Peterson v. Honeywell is a case that was actually filed on January 4th of this year, but is pretty relevant to this discussion. In 2021, Honeywell announced, like many other contractors, that it would require its employees to be vaccinated, consistent with the mandate in the September 2021 executive order. Even after the national preliminary injunction against enforcement of the vaccination mandate was established, Honeywell maintained its employee vaccination requirement. As you can imagine, vaccination requirements are super controversial right now. Anyway, Honeywell had some employees that were not thrilled about the requirement remaining in place. And in early January, a Honeywell employee initiated a lawsuit against the company with the end goal of enjoining the company from requiring employees to be vaccinated. As a disclaimer, the employee in the Honeywell case is pro se right now, and the merits of the employee's arguments are kind of to be determined. As I said, it was filed pretty recently, but the case is currently pending full briefing from the parties on a potential preliminary injunction. So it's still worth keeping an eye on. And it is a pretty fair demonstration of the potential legal and financial risk of the business as usual approach that I described previously. Next slide, Gail.
Real quick, Michaela, before we move off this slide, I would just add this is a strange situation where you're being asked to accept a clause and the government's essentially telling you they're not going to enforce it. I would just say that if you're going to do the third approach that Michaela outlined, I would try to deal with how that is going to work mechanically with the subcontractors in advance. That way you can hopefully avoid a potential REA situation. So just some diligence, some negotiation or some sort of mechanism on the front end to provide for an update if once the court rules on these issues is probably a good idea, so that your sub doesn't have potentially grounds to come back and seek an equitable adjustment after you've already negotiated your subcontract and a price and all that other stuff. So just a little pointer there.
And stepping away from the vaccine mandate with the couple of minutes that we have left in our COVID-19 segment, I just wanted to provide a quick update on a case we covered briefly last spring. The case site is in the slides, so if you want to look at this one yourself, you can. It is Pernick Circa Joint Venture. This appeal was originally heard in 2020 by the Civilian Board. The hearing resulted in a denial of the contractor's appeal. The contractor, of course, disagreed and appealed the denial to the Federal Circuit, which affirmed the Civilian Board's decision in 2021, which is why we're revisiting it briefly today. As a reminder update on the case facts, Pernick Circa concerns a contractor's decision to temporarily stop work and evacuate employees on a firm fixed price construction project that it was working on in an area that was hit especially hard by an Ebola outbreak at the time. Before it stopped work, the contractor did reach out to its government client to seek advice on how to proceed given the outbreak, but the government declined to advise the contractor and told them basically that it was a business decision and the contractor needed to make its own call. The facts don't suggest that the contractor really pushed at all to get any sort of advice or instruction, just essentially proceeded how it saw fit. When the contractor returned to work, it established on-site medical services for its employees just to protect against infection within its workforce. And it also submitted a claim for increased time and cost of performance under the contract due to the outbreak and stopping work. The government ended up granting a schedule adjustment under the contract, but denied the contractor's monetary relief. And the contractor eventually appealed to the Civilian Board. Ultimately, the decision by the Civilian Board to deny the contractor's appeal, which was of course affirmed and therefore reinforced by the Federal Circuit, hinged on the fact that the contractor in stopping work was acting of its own volition. It wasn't operating under any instruction from the government, any advice from the government. It just acted alone and based on its own judgment. The general takeaway here is just the importance of ensuring that any actions taken by a contractor, specifically in firm fixed price arrangements, like was the case in the Pernick Circuit case, in response to unforeseen circumstances like an Ebola outbreak or a COVID-19 pandemic, are supported by government direction if the contractor hopes to recover related costs that are not directly addressed under its contract. With that, I will hand the discussion over to my colleague, Caroline. She'll highlight some major 2021 cases and regulatory actions for you. Thank you.
And I would just add on that topic, I mean, this case is important for COVID purposes because this is, the likely outcome of any sort of, not in all instances, but, COVID-related litigation, requesting increased costs and things like that. This case is a template of what's likely going to happen if you were operating under a fixed price contract with a normal kind of excusable delay provision, and you didn't get very clear, specific instruction from your government contracting officer to tell you to do something in particular. So that's why we wanted to highlight it here, because it's essentially instructive as to what the future might hold if you find yourself in a similar situation based on COVID-related increased cost issues. Sorry, Caroline.
Great. Thanks, Gail. Thanks, Michaela. Hi, everyone. I am Caroline Colpoys. I'm a managing associate in the Denton's Dallas office. I'm fairly new to the Dallas legal market, to the extent any of our guests are in the Dallas area, I look forward to hopefully meeting you at some Dallas bar events in the future. As Michaela and Gail mentioned, I'm going to address a few recent cases that touch on two important topics for government contractors: how and when the Board of Contract Appeals can have jurisdiction when there's possibly fraud involved in a claim, and the accrual statute of limitations under the Contract Disputes Act. I'll then address a proposed rule issued in 2021 dealing with the reporting of R&D cost, and I'll close out with a discussion of some of the year's important bid protest cases before turning it over to Gail. So, as you can see from this first slide, I'm going to be first discussing how the Board of Contract Appeals can have jurisdiction if there's fraud involved. As we're probably mostly all aware, the FAR allows contracting officers to resolve all claims arising under or related to a contract subject to the Contract Disputes Act, except for the settlement, compromise, payment, or adjustment of any claim involving fraud. So, first case we're going to discuss is the Nauset Construction Company case at the Armed Services Board of Contract Appeals. In this case, the contractor submitted a certified claim to their contracting officer, and it wasn't until nearly 2 months after that submission that the CO responded and said that she wouldn't be able to respond to them within the 60 days required by the CBA due to the, quote, ongoing investigations by multiple government agencies. An additional 6 months after the contractor submitted its first certified claim, the CO terminated the contract for default and told the contractor again that it still did not have a decision on the contractor's first claim. Subsequently, the contractor challenged the termination for default and sent a second claim to the CO. A month after submission of this claim, the CO responded and again said that she still needed additional time to determine both claims. Given the continual delays, the contractor appealed the deemed denial of the claims to the Board of Contract Appeals. 5 months after the submission of the deemed denial of the claims to the board, the contracting officer finally responded to both claims and stated that based on the preliminary findings of the investigative agencies, her office, quote, suspected that the claims were fraudulent and that she had no authority under the Contract Disputes Act. At the board, the government argued that the claims involved fraud, so she had no authority to decide the claims, and therefore, accordingly, the board also lacked jurisdiction. The board, examining the plain language of the CDA and the FAR provision governing a CO's authority, concluded that the government was incorrect. Instead, it found that the board lacks authority when the claim involves fraud, but not when it only suspects fraud, and that the jurisdiction attached when the contractor appealed its claims to the board after the contracting officer continued to, quote, delay again and again. So the major takeaway for this case is that a contracting officer's suspicion of fraud requires the CO to refer the matter to investigative agency, but it does not divest her of the authority to decide the matter unless the matter actually involves fraud. Further, in a case like this, where the CO continually delays her decision The contractor's strong record of the delays probably helped tilt the scale in the contractor's favor. The next case we're going to cover is Tetra Tech, which was also at the Armed Services Board of Contract Appeals. In this case, Tetra Tech entered into a contract with the Navy for the survey and removal of radiological material. During performance of the contract, 2 employees of the contractor engaged in soil sampling misconduct, which eventually led to the employees pleading guilty in a related False Claims Act litigation into the company. Also, during performance of the contract, the Navy issued a negative CPARS rating against the contractor, which is what is at issue in this case. Tetra Tech challenged those negative ratings through to the CEO. In response, the CEO responded, stating that the pending FCA litigation dissolved her of any authority to resolve the claim because it could potentially involve fraud. The contractor appealed the deemed denial of its claim to the board, arguing, among other things, that the CPARS ratings were based on an unreasonable interpretation of the contract's provisions, and that the evaluations were based on unproven allegations, and that the Navy violated its duty to act in good faith and fair dealing. At the board, the government argued that Tetra Tech's alleged fraud could not be separated from its claim that the CPARS were erroneously decided, and that there could be no deemed denial of the claim when the CEO lacked authority to even issue a final decision on the claim. In response, the board held that it could consider the contractor's challenge to the CPARS rating. It held that it could consider claims when there are allegations of fraud in the contract, as long as there are no allegations of fraud in the claim itself, and if the board did not have to make any factual findings of fraud. So in this case, a more narrow and succinct statement of the contractor's claim helped ensure that the board retained jurisdiction. It particularly because there were issues of frauds kind of permeating the contract as a whole, being able to succinctly distinguish that your claims are separate and apart from the fraud that was kind of surrounding the contract it was important to Tetra Tech to actually ensure that it had jurisdiction at the Armed Services Board of Contract Appeals. Now, can you go forward to the next slide, please? Great, thank you. So the next couple cases we are going to address the accrual of the statute of limitations under the Contract Disputes Act. As we are a lot of us are probably aware, under the CDA, contractors have to submit their claims against the government within 6 years after accrual. But the statute does not define claim accrual. Contractors need to look at the FAR for the definition to understand when a claim accrues. Under the FAR, a claim accrues when all the events that fix the alleged liability and prevent assertion of the claim are known or should have been known. So the first case we are going to address deals with claim accrual when there's a possible mandatory pre-claim procedure. So the first case is triple canopy at the Federal Circuit. Under this case, Triple Canopy entered into a contract to provide security services in Afghanistan. The contract included the FAR 52.229.6, the fixed price foreign tax clause, which allowed for an increase in contract price if there was an after and imposed tax if the contractor took all reasonable action to obtain an exemption or a refund from the tax. During performance of this contract, the Afghani government issued a directive that restricted the number of staff security companies operating the country to be less than 500 people. In response, the DoD appealed the directive as it applied to Triple Canopy. Several months later, the Afghani government also then issued another directive requiring all security companies who had over that 500 employee cap to pay a fee for each person over that cap. The government issued a penalty against Triple Canopy and told the contractor that it would pay the penalty within 15 days but the notice also informed Triple Canopy that it could appeal the decision. The government once again requested that the contractor be exempted, and Triple Canopy did appeal the decision to the Afghani government. The government responded and reduced the tax, but did not eliminate the tax. And in response, Triple Canopy actually paid the tax. Then it came to Triple Canopy submitting a claim for reimbursement of those costs. Less than 6 years from the payment of the tax, but more than 6 years after the penalty was actually assessed against Triple Canopy submitted a claim to the CO seeking reimbursement. The CO failed to issue a decision again on the Triple Canopy's claims, and they were deemed denied. In its appeal to Triple Canopy first appealed the decision to the Armed Services Board of Contract Appeals. At the board denied Triple Canopy's appeal on the ground that their claims were barred by statute of limitations. It determined that the claim first accrued on the date that Triple Canopy received the tax assessment demand from the government. It also denied Triple Canopy's argument that the claims did not actually accrue until either 1, Triple Canopy paid the reduced tax, or 2, alternatively, that the claim did not accrue until after Triple Canopy exhausted its appeals to the tax, because it was required to do so under the foreign tax clause. So obviously Triple Canopy appealed the board's decision to the Federal Circuit, who agreed at the Federal Circuit that it agreed with Triple Canopy that the appeal of the tax was a quote mandatory pre-claim procedure that had to be completed before the CDA statute of limitations began to run. So thankfully for Triple Canopy, they were able to, their claims were not barred by the statute of limitations. The takeaway in this case is that if contractors are facing similar statute of limitations arguments from the government, they should examine the matter before them and determine if there were any mandatory pre-claim procedures that they were required to follow before they could submit their claim, and possibly use that as an argument going forward. The next case we are going to cover involves when the statute of limitations begins to run following the submission or the lack thereof of an incurred cost proposal. So this case is Strategic Institute, also at the Armed Services Board of Contract Appeals. This case, Strategic Technology Institute, referred to as STI, entered into its first cost type contract, which required it to submit incurred cost proposals within 6 months of the end of its fiscal year. Normally, as many of us are aware, DCA would send a reminder to the contractor if it had not received an ICP within a year of its last submission, but because this was STI's first cost type contract, they received no reminder from the DCA. So while DCA was auditing the ICPs for 2011 and 12, it noticed that it did not have cost proposals from 2008 and 2009 for STI, when it encountered a reference to those proposals in the 11 and 12 ICPs. Government requested the ICPs and STI promptly provided them, maintaining that it had already submitted those proposals at their due date. It wasn't until November 2018 that the CO issued a final decision asserting a government claim against STI. At this time, this was less than 4.5 years after DCAA requested the incurred cost proposals from STI, but it was over 9 years from when the ICP was prepared and when it was due. STI appealed the CO's decision to the board, arguing that the government's claim was time barred because either it submitted its ICPs at the due date in 2009 and 10, or alternatively, even if it didn't submit the ICPs at that due date, the government's claim accrued on that date because the government should have known that the ICPs were due then. Thus, the government had knowledge of its claim. We'll cover the first argument first. The board found that while STI could establish that the ICPs were completed in 08 and 09, it failed to establish that it's actually submitted those ICPs at the due date. In contrast, the government was able to establish through mail logs and electronic records that it never received the ICPs from STI. In response to STI's second argument that the government should have known of its claims at the due date, the board rejected that, quote, new rule that it claimed that the contractor was trying to create, that the statute of limitations began to run on the due date of the incurred cost proposal, whether the contractor submitted the ICP or not. The board considered that hypothetically, the government could have been aware of some of the questions of the of the costs if they were included in a voucher or in another way, but and that in some instances a voucher puts the government on notice. However, in this case, there was no evidence in the record that STI had submitted any evidence to put the government on notice of the impermissible direct costs to the government before the submissions of those 08 and 09 ICPs. So there's two takeaways from this case. First, make sure that when you're performing a contract that you keep detailed logs and records of every submission to the government, because the government definitely will. And two, that the contractor should be aware that the board did not prohibit the position that there are other ways that the government could have knowledge of a claim before submission of an ICP. So again, keeping adequate records could open avenues for statute of limitations arguments that the claim accrued before the date of the ICP submission.
Yeah, and I would just add, Caroline, that STI case is interesting because I think, for a long time now, it's been clear that the submission of the ICP or even subsequent updates to it is kind of the trigger date for statute of limitations claims on indirect costs. This is an interesting take in that the contractor seems to have argued that if they breach the contract by not submitting the ICP, which the allowable cost and payment clause would have required, that type of claim would have accrued, at the date it was due, essentially. Basically, if they didn't submit it within 6 months at the end of their fiscal year, then they breached at that point. But it seems like the government didn't actually make that assertion. They didn't claim that the contractor breached by not submitting it. They claimed that they breached by including unallowable costs in their ICP. So it was an interesting position. I've not seen that one taken in the past, but it sounds like it ultimately didn't work out for STI. So,
fortunately, not for STI. Thanks, Gail. I think we can move on. Yep, to this slide exactly. So now we're going to address a proposed rule regarding the submission of IR&D costs. In September of 2021, the Department of Defense proposed amending the DFARS to add a clause in all solicitations and contracts above the simplified acquisition threshold that would require contractors to submit a consolidated spreadsheet of all IR&D and bid and proposal costs incurred by the contractor during performance of any DoD contract in the previous year to a DCAA website. According to the proposed solicitation clause, the report must be submitted no later than December 31st of each year. To note, this is in addition to the required submission the major contractors already have to make to DTIC in order to claim IR&D cost as allowable under DFARS 231.205-18. As many of you are aware, that submission has to be completed by no later than 3 months after the end of the contractor fiscal year. So the proposed rule states that the purpose of the submission to the DCAA website, the one that's required by December 31st of each year, is to allow DCAA to submit an annual report to Congress on IR&D and bid and proposal costs. It does not say that it's required in order for those costs to be allowable. But we could imagine a scenario where DCAA auditors utilize the proposed solicitation clause to argue that both of those submissions, the one to DTIC and this new proposed one to the DCAA website, were required deadlines for the contractor to meet in order for those costs, those IR&D costs, to be allowable. We also wanted to point out that the proposed rule also requires a contractor to put in their submission to DCAA that the CEO, excuse me, stated that the contractor's IR&D costs will advance the needs of the DoD for future technology and advanced capability. This could possibly open contractors to an implied false certification theory under the FCA, under the False Claims Act. So contractors just need to be aware of this moving forward. The proposed rule, comments were already due to the proposed rule in November. So it's pending right now. We'll have to see if it becomes a final rule.
Yeah, and Carol, let me just make one clarification. The government's position is that you have to submit your schedule of IR&D projects to DTIC within, I think, 90 days at the end of your fiscal year. That's not actually in the DFARS. So there's a DPEP memo from, I think it's pretty old now, 2014 or something, that says that, but it's never actually made its way into the clause. So that's always kind of been a bit of contention between contractors and the government on when that's really required. But the government's position is, I think, that it's 90 days, but again, that's not in the DFARS. The other thing that's very interesting about this rule or proposed rule is that it would require you, if you have any contracts over the simplified acquisition threshold, even if they're fixed price contracts, to submit a schedule of your IR&D and B&P costs, which is somewhat odd, in my opinion, that you would require a contractor with a potentially with a very small fixed price contract to submit a schedule like this. Now, it wouldn't have any significance from a cost allowability perspective in that context, but it is still an odd administrative requirement from my perspective. I would also just note, over the years, the government has come up with some interesting proposals around IR&D requirements. Some of them have certainly not ultimately made their way into final rules. For example, some of you may recall the proposed technical interchange requirement that was, very aggressively fought back against by the industry a number of years ago. That one obviously didn't make it into the final IR&D rule. I'm not sure where this one will go. We'll see, what the comments look like from industry and how the government addresses those. But this is another potential, I would say, somewhat annoying allowability hurdle that the government might be throwing up on IR&D costs, that if it does go into effect, you're definitely going to have to be aware of, because it's not uncommon for contractors to miss that DTIC deadline and the government to say, okay, all your IR&D costs are allowable. This would seem to create another procedural rule. If you miss this deadline, the government's going to say, okay, all your IR&D costs are unallowable. So, and if you're a big contractor, you have a lot of IR&D costs, that could be a huge number potentially. So definitely something to keep an eye on.
Thanks, Gail. All right. The final thing I'm going to cover are some key bid protest decisions from the last year. So the first case we're going to cover involves standing resulting from the sale of a protester's business. Obviously, it was a busy year for corporate transactions, and particularly involving the sale of entities doing business with the government. So this is a good reminder of the standards that the GAO employs in determining if an entity can be a successor in interest to an offeror. So in this case, Landshark, a service-disabled veteran owned a small business, filed a protest at the Court of Federal Claims, arguing that the VA's decision lacked a rational basis. When the court finally heard oral arguments, Landshark informed the court that it had undergone several corporate transactions, which resulted in the company no longer owning the assets or employing the personnel that it did when it submitted the quotation. And importantly, it was no longer a veteran. It no longer qualified as a service-disabled veteran-owned small business. The GAO reiterated that the standard for valuing whether a following entity could function as a successor in interest was whether the entity, the veteran entity asserting standing were the same legal entity and business unit, and whether the change in corporate structure or sale affected the operational or financial resources of the entity asserting standing. So I think the big takeaway for this case is to ensure that the deal people understand the implications of the proposed changes to the contractors any pending bids. The next case we're going to quickly cover involves the ever important blue and gold rule and the government's attempts to expand the rule. To reiterate, the blue and gold rule states that a disappointed offeror waives any protest grounds that it may have had to the terms of solicitation if it could have raised those protest grounds pre-award. At the Court of Federal Claims, the government argued that this rule should also be applied to corrective action challenges, essentially that it should be applied in the interim time from when the GAO recommends that the agency takes a certain corrective action and when the agency actually takes that action and awards the contract to the new awardee. The court refused to extend the blue and gold rule that far, finding that the Federal Circuit has not indicated that the rule should apply out of the context of a protest to solicitation. The next case we're going to cover addresses the departure of key personnel during an agency's corrective action period. In this case, Ashland Management Group filed a protest challenging the award to BAH. The agency took corrective action and stated that it would reconsider the award. And after completing that corrective action, the agency again issued the award to BAH. But during that time period of the initial award and the completion of the corrective action, one of BAH's key personnel left the company. To remind those on the call, if the solicitation requires offerors to name key personnel, the unavailability of those proposed key personnel is considered a material proposal change, which affects the proposer's eligibility of award, and the offeror is required to notify the agency when it has actual knowledge of the person's unavailability prior to award. In this case, GAO found that the contractor had actual knowledge of the individual's departure because the company actually received the individual's departure letter during the corrective action period. So GAO sustained the protest. So takeaways to keep good records of your key personnel availability and don't try and avoid notifying the government when you were required to do so. The final case we're going to quickly cover involves whether an IDIQ holder has standing to protest the award of other IDIQs. Novel argument from Aerospray, who was an IDIQ contract awardee, who challenged the award of the other IDIQ contracts, not the task orders, to the two other companies who were also awardees. Aerospray argued that it had standing despite being an awardee because the award to the other contractors increased the competition for future task orders. Not surprisingly, the Court of Federal Claims rejected Aerospray's argument for standing, finding that an awardee by definition is not an actual prospective offerer, and due to the nature of IDIQ contracts, an awardee has no legally cognizable expectation of receiving future task orders, but only a guaranteed minimum quantity of orders and a fair opportunity to compete for future task orders. So with that, I will turn it over to Gail. Appreciate everyone's time today.
Okay, thanks, Caroline. Before we get going on 2022 issues, it's time to give the keyword or the key code word for those holding licenses in New York, New Jersey, and Pennsylvania. The code must be typed into the chat session, the little speech bubble on the lower right-hand side of your WebEx screen. The code is SPRING, S-P-R-I-N-G. It's on the slide as well, and in case you missed it first time, the code word is SPRING, S-P-R-I-N-G. Okay, so now we're going to turn to 2022, things that are happening, things that we think are going to happen, and other trends that to be aware of throughout this year. We'll see if we're right at the end of the year or not. The first issue that we want to talk about relates to intellectual property. As some of you may know, there have been a number of technical data cases at the board and the court over the last couple of years. There was a Boeing case that a couple of decisions came out on. There's a pending flight safety case actually at the board that deals with technical data related to commercial items. And then there's the Raytheon case at the Court of Federal Claims. We've talked a couple cases in the works now for several years, but we're at a point now where we're expecting to get potentially a decision, later in 2022. The crux of the case is really about whether or not supplier lists that Raytheon maintained in connection with its performance of government contracts are technical data or not. now you might be saying to yourself, well, isn't the term technical data defined in the DFARS? I mean, how controversial could that be? But interestingly, in this case, it actually, I mean, you'd be right, one, in thinking that, but two, that is the crux of the issue. The government has taken the position that these supplier lists are technical data, whereas, of course, Raytheon disagrees with that position. The government's main position, and they've offered a few in the case, but it's essentially that anything useful to an Army engineer is technical data, or that anything containing a part number is technical data because the part number usually ties to an actual drawing number. And in this case, because the lists that issue under the government's theory of the case are technical data under those standards, and some of the underlying costs to develop those lists may have been charged as direct costs to the underlying contracts, that the government is entitled to either a government purpose rights license or an unlimited rights license. And they've kind of oscillated a little bit back and forth between the two throughout the case. Now, I will just mention that we are representing Raytheon in this case. So, of course, we disagree strongly with the government's position because, for one, we think it's inconsistent with the term technical data as it's defined in the DFARS, but also the government's position would seem to create a very unworkable and subjective standard. It's not clear to us how a contractor could have any certainty as to what is or is not technical data if the standard is anything that's potentially useful to the Army's technical people, and that would certainly seem to expand the scope of technical data well beyond what anybody has previously contemplated. So, we think there's good reason to disagree strongly, obviously, with the government's position. In addition, there's in the complaint and in the motions, Raytheon has also asserted that even if the supplier lists are technical data, the government is certainly not entitled to GPR or an unlimited rights license in that data. So that issue is also, before the court to some degree. Throughout 2021, cross motions for summary judgment were filed, so both parties have moved and fully briefed those issues. They're before the court right now. We're expecting sometime, hopefully in the near term, to have a hearing at the court on these issues, and then we're hopeful maybe by towards the end of 2022 that we'll actually have a decision. We think that the outcome of this case will be significant either way. Obviously, we hope that Raytheon wins, and if they do, it would be very useful to industry because we'd have we'd have a basis for contractors to push back on potential government overreach in this area, and which we've seen in recent years. Conversely, obviously, if the government wins, this would seem to embolden the government to be more aggressive in declaring that contractor information is technical data and then seeking what could be a very, very broad license in that data. So this is definitely one to watch in 2022. So the next issue that I want to talk about is the pleading requirements for fraud cases under Rule 9. And this is an issue that's at the Supreme Court right now. So for those of you that aren't familiar with it, Rule 9 of the Federal Rules of Civil Procedure requires that fraud allegations be pled with particularity, essentially the who, what, when, where, and how of the alleged fraud. Pleading with particularity is important in fraud cases for lots of reasons, but also for public policy reasons because of the very serious nature of fraud allegations, right? So the normal notice pleading requirements that apply in civil litigation do not apply to fraud allegations. They have to be pled under a heightened standard. And in the False Claims Act or the FCA context, Rule 9 is a potentially very potent defense for contractors because it requires a qui tam relator or the government, if the government's the plaintiff, to allege very specific facts in the complaint or risk dismissal of the case, oftentimes with prejudice, right? So a lot of FCA cases start out with motions to dismiss under Rule 9 and then adjudication on whether or not the complaint can even survive. And the case that's mentioned here, Johnson v. Bethany Hospice, is an example where that happened. Essentially in the case, the relators were two or three former employees of Bethany Hospice. So they had access to records and they presumably knew what was happening at the company. They alleged in the complaint a very elaborate scheme to violate the anti-kickback statute applicable in the healthcare context, but they didn't actually provide evidence of any specific claims that were submitted to the government that were false. They didn't have the who, what, when, where, or why. So the district court dismissed the complaint. They appealed to the 11th Circuit. The 11th Circuit upheld the dismissal, and then now the case is at the Supreme Court to resolve a circuit split over how strictly the Rule 9 pleading requirements should be interpreted. And the court recently asked the government to file a brief kind of weighing in on this issue. So, for people practicing the False Claims Act area, this is a potentially very important decision. So we'll see how it comes out later this year. The next one that we want to talk about is the Aerojet decision that just came out a couple of weeks ago out of the Eastern District of California. So this one relates to cybersecurity in the FCA, which is a topic that I know we've talked about during a presentation that we did last year. We also talked about the DOJ initiative from, I think, just last October, where they're saying that they're going to use the FCA to root out contractor noncompliances with cybersecurity requirements. So it's a real emphasis area for the government. Now, this case predates, that DOJ initiative and some of the other emphasis that the government's been placing on this in recent years. But, the outcome of it could be important or at least instructive for future matters. The actual decision that came out recently is not that interesting because it essentially denied, for the most part, the parties' cross motions for summary judgment because there were still material facts to be resolved. But what will be interesting is the ultimate outcome of this case, assuming that it goes to a decision of some sort, because Aerojet's primary defenses, at least in its MSJ, are that that the government was aware of the noncompliances and therefore they were immaterial, or alternatively that the claims could have been submitted knowingly with the requisite scienter because, again, the government was aware of their potential noncompliances with the cybersecurity requirements. Aerojet has also argued there's an interesting damages issue on the table as well. Aerojet has taken the position that the government suffered no damages as a result of the noncompliance in one regard because they got the value of the contract that was performed and presumably the government didn't think it was material either. The relator, of course, sees it very differently and is basically saying that every claim for payment that Aerojet ever submitted under contract with these clauses was fraudulent, and therefore, so it's about a $20 million swing either way. So it'll be interesting in 2022 to see how this case plays out, because, to the extent that these defenses work or don't work for Aerojet, that will be presumably very instructive for other contractors that might find themselves in the crosshairs of an FCA allegation stemming from noncompliances with the cybersecurity requirements. And it'll also be interesting to see what happens, if anything, on the damages issue. Some of you may recall there was an SAIC case from about a decade or so ago that kind of dealt with this issue of what is the scope of damages in a situation like this where you have a noncompliance, but it doesn't necessarily impact the value of the services that were provided to the government. So this could be an opportunity for another court to address that type of issue as well. And finally, in the last couple of minutes here, I want to talk quickly about increased antitrust enforcement. Many of you might have seen in the news last week that the Lockheed Martin is no longer going to pursue its acquisition of Aerojet based on, presumably among other things, the FTC's stance and other. There's been a lot of congressional and other howling about consolidation in the defense industry. So that's a potentially significant development. And then relatedly, just this week, I think it was just this week actually, Raytheon announced that they, are being looked at for some potential anti-competitive hiring practices. Obviously no idea if any of that has any merit, but in looking at that, you can see from a couple of years ago, the government did stand up an initiative to kind of further scrutinize, practices of businesses and contractors is included in that in terms of, anti-competitive behavior. There's been a number of criminal and civil actions brought against a host of companies in the last few years by the government, not just contractors, but companies, doing all sorts of business, right? So it certainly appears to be an emphasis area for the government. And then maybe coincidentally, maybe not, DOD also issued a report this week, which isn't inconsistent with their position in the past, but essentially complaining about consolidation in the defense industry as well. and expressing concerns that, there just aren't enough, big contractors anymore, and the companies are all kind of integrating vertically, et cetera. So, I think the combination of these facts certainly could be a signal that 2022 could be, a year where M&A activity, at least in the government contractor space, is more heavily scrutinized by the government. So definitely something to watch. Obviously, M&A activity has been up over the last couple of years. We'll see, what kind of effect, if any, this has in 2022. So with that, we are out of time. I want to thank you all for participating today. In approximately 15 days, you will receive an email with a link to your CLE certificate. Your webinar login details will be used to process these certificates. No additional steps are necessary. As a reminder, the code word is only required if you're seeking credit in New York, New Jersey, or Pennsylvania. And with that, please reach out if you have any questions, and thank you all for participating today.